Hi friends, Dave Hagan here. I want to spend just a few minutes telling you about a recent U.S. Supreme Court case that dealt with the ability to protect IRA accounts. This is important to all of us that have IRA accounts, but also important in any situation when representing a potential debtor or creditor. The Supreme Court recently held, in a unanimous opinion written by Justice Sotomayor, that an IRA account that was inherited from someone other than a spouse may not be protected in a bankruptcy filing. Now let's step back for a minute and look at the big picture. Traditionally, ERISA-approved retirement accounts were exempt from creditors' claims and exempt in a bankruptcy proceeding. The Supreme Court made this clear in 1992 in a case called Patterson v. Shoemate. Non-ERISA qualified plans, most notably IRAs, were exempt under California law that exempted retirement plans, but only to the extent they were deemed reasonable and necessary for retirement. This led to a great deal of litigation, as reasonable and necessary can be a very fluid standard. 8 years ago, Congress, as part of its bankruptcy reform legislation, provided a federal protection for IRA accounts up to a certain dollar limit, which is currently about $1.3 million. This protection was over and above any potential protection provided by state law. The Supreme Court has now cut back on this protection in holding that an IRA inherited from someone other than your spouse, like an IRA inherited from a parent, is not exempt or protected. Their reasoning was that the funds were not retirement funds in the hands of the recipient. This means that in any potential creditor-debtor relationship, you always want to ask the question, did you put the funds in your IRA account, or did someone inherit those funds and give them to you? Now, there's ways to plan ahead and prevent this result. For example, if the beneficiary of an IRA account is not a child but rather a spendthrift trust, the funds may be protected from potential creditors of the beneficiary. Certain types of trusts can qualify as designated beneficiaries for IRAs and provide full protection. However, special care must be taken to ensure that the trust does not allow the beneficiary too much control over the funds held in trust. Well, there you have it. This is Dave Hagan, and you are up to date.